Hello, I'm Judge Dodson in the Family Court of St. Louis County. It is not unusual for judges in family court to see parents and spouses in our courtrooms who are having trouble talking with one another and making decisions together, especially when they have recently separated. It can be very uncomfortable, and there can be strong emotions about the changes that are occurring. For parents, it can be hard to see each other or talk on the phone about the decisions they need to make for their children and for their future. It can even be hard to imagine what the future might look like. It is very important to the judges in St. Louis County to do what we can to help you make decisions together about these issues. In the fall of 2021, we passed a rule in our court requiring most parents to attend mediation with a trained mediator so that parents have some help with these conversations and the decisions that need to be made. We want to make sure you know more about mediation before your first meeting with a mediator, so we have prepared this video to help you understand more about what will happen in mediation. Before you attend mediation, you'll need to pick a mediator, and we will give you more information about that at the end of the video. There is a form that should be completed and submitted to the judge showing you plan to attend mediation and who your mediator will be. If you are represented, you should spend time preparing for mediation with your lawyer so that you can make good use of your time with the mediator. After you make an appointment to meet with the mediator, you may go to the mediator's office or meet online with your mediator. The mediator will get to know you and your partner or co-parent by listening to each of you. And when you arrive for the mediation session, the mediator will ask you to sit at a table with your ex-partner like a business meeting. The mediator will introduce themselves and tell you more about how mediation works. You may sign an agreement to mediate if you have not done so before the meeting. The mediator will usually ask each of you to explain more about the situation, and they will ask questions and look at information that helps them understand the details. They will also make sure you both understand the information and the questions needed to make decisions. If you have children, the mediator will ask questions about how you want to work together as parents for your children. The mediator may also learn more about your financial information, such as your wages or the property you own. After the mediator understands the information, the mediator will help you start to consider the options and work with both of you to weigh options, look at compromises, and negotiate solutions that best address the concerns and what everyone needs to move forward and complete an agreement. The mediator will also create a document that shows what you have agreed to in mediation, and that's called a Memorandum of Understanding. It is important to understand that mediators are not judges. Mediators are neutral and do not represent either party. They cannot take a side or decide what is right or what is wrong. Also, mediation is confidential, so your mediator cannot tell the judge in your case what happened in mediation, and they can only talk to your lawyers if you agree. This helps make it easier for you to talk about your concerns and choices. When you are done working with the mediator, and if you're both satisfied with your agreements, the mediator will send the written documents with your agreements to your attorney, and your attorney will pass the information to the judge, who will review the agreement, approve it, and sign it. We hope that this demonstration will help you in your mediation process. For more information, review our website at stlcountycourts.com.